Hello and welcome everybody. Very pleased to welcome you today to the Law 2022 online family law shaped a debate with myself, Safda Mahmood,
And
and
me, Elissa Costa-Waldman, and actually we think it's Law 2025.
absolutely Law 2025. Thank you very much indeed. Absolutely. Where have I been? Absolutely. Thank you. Thank you. And so this session, of course, is going to be lasting approximately an hour. And what Alyssa and I are going to be doing is going through some of the latest developments in family law featured in Law 2025 online, as well as looking at some of your pre-submitted questions. Now, with the if you didn't get a chance to submit your questions ahead of the session, don't forget to sign up to the solicitors group emails to be alerted on upcoming family law shape the debate sessions, as well as regular, relevant, and also professionally curated updates to support you in practice. And also, if you haven't already done so, you can still purchase the full law online today, which gives you full access to the sessions and also the topics that Elissa and I will be discussing today. So, by way of introduction, just a few words then about the speakers. So, firstly, about myself, I've got experience in practicing and also teaching family law and children. It's coming up to 31 years now, in fact. So, 31 years, gosh, where does the time fly, they say? And I practice predominantly in children proceedings alongside the lecturing side and also legal writing. And accreditation wise, I'm a member of the Law Society Children Law Accredited Scheme, have been now for, I think it's about 25 years, in fact. And also an assessor, author, having written for various publications, including for the Law Society. And I'm hoping today will give you a useful insight into some of these legal developments. So today then I'll be looking at relationship breakdown. Is it a divorce? Is it dissolution? Is it nullity? Or is it judicial separation? And then secondly, I'll also be covering some elements of the Domestic Abuse Act of 2021, some subsequent developments and updates into 2025. So there we are. And then over to yourself, Elissa.
Yes, so I'm Elissa Costa-Waldman. I know lots of you know me already. I'm a barrister, a mediator, collaborative lawyer, family law arbitrator. Like Safda, I do a lot of writing. I'm currently reviewing my chapter in Resolution's Cohabitation Claims Handbook, the new third edition coming out soon, which deals with Talata claims. And as you know, I like my Talata stuff. And one of the things I'm going to be talking about today is how to run a successful Talata claim and looking specifically at TR1s. Um, so been in the law. Actually, I've been in the law lots longer than Safta because I used to be a legal secretary. So I've actually been involved in the law for 52 years, but
Wow.
a barrister for almost 35 of those, and most of which time I have done my barristering, writing, lecturing, and stuff. So Safta and I do very much the same kind of stuff. I tend to specialise in money and Talata claims, although we both tend to talk about each
Mhm.
other's areas, and I think that's what makes for an interesting time for you guys. So, Safra, if it's okay with you, I'm going to go to the first delegate question because it's about money.
Amazing. Thank you. Thank you.
It's a procedural question, and somebody has asked, and I really sympathise. So here's the question. As we have to front load financial remedy applications, 5 weeks never really seems long enough to review for me, draft questionnaires, ES1, ES2, get current property and mortgage info, try to agree fast track directions. It seems we're expected to do a lot more within the same time scale. Does anyone else have this issue and think we should get more time? Do I need to be more organised? Because it's very difficult being a sole practitioner. Totally understand. I do a lot of direct access cases, so I know, I feel your pain. So first things first, it does seem that there's a bit of conflation of the old timetable with a slightly new procedure that doesn't seem to have found its way into the rules, but is definitely into the new Form C that we all get. Here's how I think you manage it. First of all, you can't draft your questionnaire until you've seen both sides' Forms E. So it really is incumbent on both sides to get their Forms E done within the 5 week timetable.
Mhm.
That's number one. Get your clients to do as much as they can as early as they can. Send them a for me, an empty one, and say, do your best. I'll do the rest. That rhymes. There's a reason.
That's very good.
So you remember, right? And do that really early on, so that if you know somebody's made an application or your client's the one that's likely to be making that application, give them an empty for me and tell them, I often sort of highlight the grey
Mm,
areas and say, this is where you need documents, make sure, start getting it together. The earlier they do it, and also I think the more they can do for themselves in the wake of relationship breakdown, what you are doing is you are giving them a sense of empowerment that they're
mm,
able to do something themselves rather than just sort of, adopt that victim mentality. Your questionnaires do not arise until you've got both sides Forms E. So you don't have to do all that at the same time. So you need to sort of try and prioritize things. And if you've got lots of clients and you're a sole practitioner, I know it can feel like back at university with all your essays having the same deadline. You
mm,
have to prioritize. ES1, ES2. Again, you can get a blank one, start doing it as early as you can in any case that you have, and then you're going to be ahead of the game. Um, it's the client who needs to get the property info and the mortgage info, not you. So you have to make sure that your client knows this is a collaborative exercise and they have to do their bit as well. And I think if you have good kind of case management software, if you have, even if it's just, a notebook and a list, a to-do list, make sure you have one and you set it up in your diary, all your deadlines for different cases. It can be done. They wouldn't, I like to think, like God, give us more than we can handle. So I think it can be done. It does take a lot of organization. Sometimes it's really difficult. And when it is difficult, write to the other side and say, I'm so sorry. Would you mind if I had an extra week? Because as long as you say to someone, look, I'm having a bit of difficulty, and you're honest, generally they'll agree.
yeah,
And once they've agreed, when the time comes that they need that extra week, you'll give it to them too. So it's about being collaborative and making sure that you don't have to do all of it. Give your client some of the burden because it's their case.
that's fantastic. That's really, really helpful. Listen, as a kind of side kind of question, if I may, in relation to that is, I suppose, because I know when I do a lot of the children proceedings, for example, I found over the years a lot of the children work has become quite front heavy as well, front loaded. So whether it's
Everything is front
everything
loaded.
has, and as you say, it is a lot to do, but as you say, as long as we plan it,
Yeah.
it pays dividends, doesn't it? Because then you go
It's
to that
yeah,
FDA and you're there, and you know what the
yeah,
real issues are.
yeah. It's like
Um,
anything.
yeah,
It's about don't leave it all to the last minute because it won't work.
yeah.
You have to plan and prioritize.
Elissa, with because I mean, there's so many pilots out there that we're just so inundated, aren't we? And there's that express financial remedy
Oh, I know.
pilot.
Well, yeah, I mean, it's
Yeah,
interesting. You say express.
yeah,
So we've already
mm,
got in financial remedies, we've got standard procedure
yeah,
and we've got a fast track for
mm,
simpler cases. The way I see the new pilot, which appears to be piloted very much in the north, not down
yes,
here.
absolutely, yeah,
And it's interesting, isn't it, culturally,
mm,
because that seems to me, and let's not forget that all our financial and all our family procedure rules are based on the civil procedure rules that
yeah,
came in way back in 1999.
mm,
That's what they're based on. And in the civil procedure we've got small claims, fast track,
yeah,
intermediate,
mm,
and multi-track.
mm,
So there's four tracks. So now what they're looking at in financial remedies is as well as your standard and your fast track procedure. And I think those financial claims that fit into fast track are very limited.
mm,
What I see this new kind of pilot scheme designed to do is not a fast track necessarily, but a simplified standard procedure for smaller claims.
mm, yeah,
So smaller matrimonial pot. So, for example, where the pot isn't worth more than 250,000,
Mm.
and sometimes you won't be able to say because, if you've got a sort of the value of a house on the cusp, it might be more difficult to
Mm.
determine where should it go in that, or should it, where do I put it? But if you've got what is essentially what you and I would call a modest or a small money case,
Yeah.
that's 250,000 or below, all in, then I think it's really helpful to have a more streamlined procedure
Mm.
because if the parties haven't got a lot of money, they don't want to be spending a lot of money on a lot of front-loaded litigation. They
Yeah.
want something that is easier to manage.
Mm.
And so I think you've got a procedure that is, in a way, easier to manage both from the court point of view and ours,
Mm.
and recognizes that not all money is big money.
That's right. That's right. And really just kind of thinking that through, Alyssa, because of course with your, vast experience on the Talata side, you'll be very familiar, of course, with, Part 7, Part 8
Oh,
of the
yeah.
CPR. And of course, the Part 8 are more simplified where there's no substantial dispute as to fact. Do you feel that this express financial remedy pilot, are they kind of almost trying to do something like that, you think? Almost simplified, less
We'll definitely
documentation, less,
simplify
yeah,
it, but
yeah.
I think primarily, and I think it's interesting that it's up north, where I
Yes.
do think, it's not London. London's where you get the big Russian cases because
Yes.
they've got lots of money.
Mm.
London does appear to be the area where people come if it's a high net worth case.
Mm.
So I do think it's being piloted in those areas where it has been demonstrated that those parties getting divorced in relationship breakdown don't have the kind of
Yeah.
marital quest that you get down south. I think that
Yeah.
I do think there is a sort of cultural reason for locating it, that
Further.
pilot geographically where it is being located.
Yeah.
Um, it will be interesting to see how it pans out, but I really do think it's a recognition of lots of more modest money cases
Mm.
and that you can't have people's, when money means more
Mm. Yeah.
somehow, or lack of it means more, it would be helpful to those people to have a procedure that is less expensive. And I think
Yeah.
that's the whole point of it.
That's the point of it. Yeah. No,
Yeah.
that's really helpful. Thank you. Thank you very much indeed.
Welcome.
Okay, excellent, great. So what we'll do, we'll look at maybe one of the other questions, looking at
I'm going to
uh
ask you a question.
yeah, go for it. Absolutely.
What
Absolutely.
is the effect, I like this, of a nikah, an Islamic marriage conducted in this jurisdiction in terms of pursuing financial orders?
Okay,
And I'm
fantastic.
I'm taking that question, whoever wrote it, to mean that they did not necessarily have a civil wedding too.
Right. Okay, thank you. Well, of course, what we're looking at there is the situation where with the nikah, which would be the Islamic ceremony, if that celebration has taken place, and let's assume it took place, say, in Pakistan, for example. Now, if it took place in Pakistan, you wouldn't have that difficulty, of course, with being able to pursue a financial order because it's conducted in a country where the nikah is, of course, the custom of that country, i.e. the law where it's celebrated. But as you say, if it's here, that's where you got the difficulties. If it's in England and Wales, that's where you got
I'm
the
thinking,
difficulties.
they did it in a restaurant.
Yeah, yeah, absolutely, absolutely. So, I mean, there was certainly the case of Akhtar Khan some years back, 2018 and 2020. The Court of Appeal looked at that. And even though at the initial 2018 decision by Mr. Justice Williams in the High Court, he said, look, I can't regard this as a marriage because it hasn't complied with the Marriage Acts. But what will do is I'm going to apply a very liberal approach, and I'll regard this, applying that flexible approach, and regard this as a void marriage. Now, of course, by doing that, he's opened a doorway to pursue a financial order claim through Section 11 of MCA. But of course, the Court of Appeal said, hang on a minute, how have you done that? Because a marriage, of course, is a process. The process is you need to comply with the civil elements here as well, given it was a
All the
non-Anglican marriage.
formalities, you've got to
Ab-
get married somewhere where it's licensed and
Absolutely.
all the
And
stuff.
And because they didn't even do that, I mean, they didn't even try, and to be fair to the wife, she was putting pressure on the hubby. And I use the word husband and wife loosely here, of course.
Yeah.
Um, she put pressure on him and said, "Come on, when are you going to organize that?" He never did. And 18 years later, 4 kids later, many holidays later, um, when she decides to lodge a divorce, of course, she's hit with the response, which is very sorry, but actually, it's not a valid marriage. It's not even a void marriage. It's not even a voidable marriage.
It's kind of,
It's
sorry,
it's
you
an
can't get divorced because you weren't actually married.
absolutely, it's a non-marriage. It's a non-marriage, and hence, of course, this is where Elissa's clients in that situation, no doubt, will be coming to yourself to say, "Well,
The Talata case then,
Talata,
isn't it? Yeah.
absolutely."
Yeah.
And that's really where we are at the moment with those kind of marriages. And rightly or wrongly,
Because
that's
nothing has really changed, has
yeah,
it? It's
yeah,
it's that court of appeal that we're stuck with. So, I mean, it's a pity, isn't it? I always think it's a pity that the cohabiting couples don't come to us before they
mm,
start cohabiting.
yeah,
The conveyancers never pick up or advise people who are
mm,
buying property together what they might like to do to protect
mm,
both of them.
yeah,
And similarly, and I don't know, would it be the imams? Would it be from the religious side to say,
yeah,
I know you want a religious wedding, that's really important to you, but in this country, in case
yes,
God forbid it goes wrong, you need a civil wedding too.
absolutely. And in fact,
Is that incumbent on the religious leader?
it's really interesting question because I mean I know as a fact a number of people who have been in this situation. The imam, to be fair, will say to them when they are doing the marrying, so to speak, they will say, "Look, this marriage isn't going to be recognised under English and Welsh law." But I think that's where it stops. And really, in my view, they need to go much further. They almost need to kind of drum it into them. For
Yeah,
example, for example, language could be an issue. What if, say the husband, for example, say, he's able to have a good enough command of the English Welsh language, but let's say the wife doesn't, and
yeah.
she's entirely dependent on him and his family. Now he could be, sadly quite devious and think, well,
Oh.
I'm not going to tell her, I'm not going to let her understand this
Mm.
because
Yeah, because he
you know
doesn't want her to
he
have
doesn't
the
want it.
rights that
A-
come with being married in this.
Absolutely. And that's really perhaps one of the drawbacks with this, because it's almost upon whom is that kind of responsibility. Should the imam, should, for example, the person who's doing the marrying, be
Yeah,
expected
I
to
mean,
go
I was
further?
just suggesting that
Mm.
because I couldn't think of anyone else.
No, it's good, and I'm glad, and I personally think there should be that greater expectation upon them, because if they don't do it, who will? Who? Yeah, so I'm with you on that.
Yeah.
And this is a difficulty, isn't it? Because as then when it comes to Talata cases, 18 years. I know they settled in that Actor and Khan case, but had they not, 18 years together, 4 children. Let's assume everything was put in his name. You're going to have to plant that
Oh,
beneficial interest
that is going to
argument.
be so
Yeah,
difficult.
yeah,
So difficult. And interestingly, I am reminded because going back to sort of cohabitation cases, we've got our own English mess, haven't we?
that's
Because
right.
going back to Valerie Burns,
Yes,
1980, 1984,
yes,
nothing's changed. Nothing's changed.
yes,
Valerie Burns changed her name to Mrs. Burns to give her the aura of respectability because she was living
yes,
with someone. She had his kids. She gave up work. She did everything that a wife would do,
yes.
except she wasn't the wife. She got nothing.
She got nothing. That's
And
right.
it's the same situation for Muslim brides who do
Mm,
not have the benefit. If they marry here under Islamic law, they
mm.
do not have the benefit without a civil
Oh,
ceremony of the English law jurisdiction if it goes wrong.
that's right. That's right.
And
That's
I mean, in a sense, you're sort of leading me down a path here because when you say, what if the husband's got a good command of English?
mm,
What if she hasn't? And generally
mm,
speaking, certainly I know the Indian and the Pakistani brides tend to live with the
mm,
husband's family.
mm.
So they're all kind of in control. It's
Yeah.
almost like a kind of coercive and
I,
controlling
I,
environment,
I
is it? economic abuse at that
Absolutely.
level, isn't it?
Absolutely. Isn't this, I mean, potentially, if there was a repetition of this type of situation, because there's that financial remedy case, wasn't there, a few years ago, that DPNM EMP case. It's the one where the husband believed he was husband for about 25 years, only to find out that in fact his wife's already married to another bloke. So of course, he goes for nullity, and the judge decides to hold economic abuse.
Yeah.
So you're right. I think because of the Domestic Abuse Act and our wider appreciation and understanding of coercive controlling behavior economic, I wouldn't be surprised if somebody runs that argument, at some stage, particularly to say, actually, this person took advantage by
Absolutely.
deliberately blocking, the civil ceremony, and therefore putting goods and services outside their reach.
I mean, in a way, Actor and Khan, it was as if the husband blocked the civil ceremony
Yeah,
because he kept asking, she kept saying,
she did. Yeah,
"Why?"
that's right.
Um, but I think it's not, what worries me is for us as the lawyers, we're there to sort of try and resolve the mess. But ideally, we need to avoid the mess in the first place.
That's right.
And and again, I see that as by way of education.
Mm, yeah.
But how, and that I think is the big problem. How do we educate potential clients? It's all very well you can say to other lawyers, well, you tell your clients they can have a cohabitation agreement,
Mm.
um, whatever. I've got another question for you about your nullities and separation.
Yeah.
Um, but you can have a
Mm.
cohabitation agreement, but people really they don't know about
Don't
it.
know about it. That's the thing.
And
And,
and I tell you what's interesting, because it occurred to me the other day, I sort of had a light bulb moment that with a prenup currently doesn't have contractual force
mm,
because it comes within, it might be given weight
yes.
in a financial remedy case where judges still have huge discretion.
Mm,
But if you have a cohabitation agreement that is signed as a deed, you've got something that has got contractual force.
absolutely. Absolutely.
So, well, they don't have a statute that gives them all the rights and remedies that married people have. But on the other hand, if they had that cohabitation agreement,
Mm.
they'd be doing better, wouldn't they?
I'll be doing a lot better. Absolutely. That's right. That's incredible.
Yeah. So,
I,
I wanted to ask you, um, when when you deal with people that want to separate
mm,
and ultimately, it's going to end in divorce, would you recommend a separation agreement?
in some respects, yes. In some respects, I would, for a number of reasons. One, I suppose, even let's assume once they have even lodged a divorce, because with this new act, we've got, of course, a Divorce Resolution and Separation Act, which, in fact, just a few days ago, 3 years it's been enforced now, which is
Oh, is it
incredible how
really?
how
Oh,
long it goes.
doesn't time fly, Safda, when you're
Absolutely,
having fun?
absolutely. But of course, that act, it brings in this mandatory 20-week period. So of course, let's say I upload the divorce application on the portal today, court issues it, say in a week or two's time. We've got this mandatory 20-week period unless we exceptionally apply to expedite it. Now, what if, I'm for husband and he says to me, looks after, as well as, you lodging a divorce for me, we've done all the hard work because we happened to listen to this webinar that Elissa was saying that really you need to do a lot of the work beforehand. So we've done that. We've done that. And actually, look, here you are. We've done a draft consent order for you. It's all done and dusted. We've even done a D81 for you. Um, but of course, I'm saying to them, that's all fantastic, but you know what? I can't do much with it until we apply for conditional order, which I can't do for another 20 weeks yet. And he's saying to me, well, look, we've got a buyer for the house. With everything that's going on in the US, obviously with the tariffs and everything, we don't want that to go. We don't want to miss out there. That buyer is willing to pay the asking price. What do we do? Do we risk it because we want a Section 24 A order for sale, or do we sell the house and put it down as a recital? What do we do? And it's those kind of situations where I think separation agreements are quite useful because it's almost saying to them, well, look, I can't do a huge amount for you yet, but why don't you put a separation agreement together? As you say, just like with cohabitation agreements, get it signed, dated as a deed. And okay, fine. We can't say absolutely it will carry the same force as, say, a cohab agreement will, but we'll go down a notice to show cause as to why it should not be upheld if the
Yeah.
other person tries to argue against it. So I think that's perhaps one example where more and more lawyers are doing separation agreements,
Mm.
for that. Um,
Ahead of doing
yeah,
one, would you get them each to do a Form E to disclose
yes.
everything?
Yes, it's definitely absolutely because, of course, more likely then to avoid, being not upheld or not being given that weight.
Yeah, because you'd want to
Absolutely.
have a recital in it that they both given full and frank disclosure.
Yes.
Yeah.
Yes, that's right. Interestingly, talking about, for me's, there was that Helliwell case last year, Helliwell, where, big money case, of course, she's worth 65 million, he's worth, what, 850. And wasn't he complaining in that case saying, oh, well, look, we signed up to this prenup, but she didn't provide me with a full and frank disclosure. The judge said, look, you knew she was a multi-millionaire,
Hey,
you know.
it's
So
not like you didn't know.
absolutely. So, I mean, do you feel, I mean, Alyssa, on that point, do you feel that, because I know it's the gold service, isn't it, that Judge described as, if you got full and frank, you had these
Mm.
Form E's, but that's the gold service. But do you feel, as that case decided, that as long as they've got a reasonable appreciation of the other person's financial
I
position,
have
that
to
should be
say,
enough?
for the protection of the lawyers, I would prefer to go down the Form E route.
Yeah.
But
Mhm.
not necessarily to sort of, as long as you could disclose perhaps more minimally
Mhm.
what you've got, you don't necessarily have to go back 2 years or whatever, or a year even, but, just to say this is what's in this account, that account,
Mhm.
because if people are multimillionaires,
Yeah.
yeah.
Absolutely. It's after a
So
while,
let's be
five,
proportionate.
yeah, absolutely. 5 million here, five, it
Yeah.
doesn't
But I
really,
think a
yeah.
lot of it, certainly for our audience,
Mm.
it's not just about the parties, it's about covering your back.
Yes,
Because recently, even Fiona Shackleton, Baroness Shackleton, was being sued about the yacht.
yes,
So,
yes, absolutely.
it happens to the best of us. And I
That's
think, these days more than ever, you have to look over your shoulder and
ab-
cover your bottom.
absolutely,
Quite
absolutely,
difficult, you have to be a contortionist, but you know what I mean.
absolutely. No, you're right. Can I now throw one of the questions to you on the Talata side, a specific one?
Okay.
Now, I've always been interested in this one, and it's this. It's of course, sometimes people will purchase properties jointly, either as joint tenants in common. We've got a good old stack and dad in line of authorities. There's always been this form available, the JO.
Yep.
And why is it? Why isn't it, you think, that there's
I don't
more
know why.
widespread use of the form
Yeah.
JO?
So the guys that are watching us, it's probably new to them in my presentation, the Form JO. The whole point it was brought in was because things happen with a TR1. It doesn't get signed. It
Mm,
doesn't necessarily get signed by both parties. The boxes don't get ticked. There's often a problem because of that flurry of activity on the day of completion. Sometimes people even complete exchange and complete on the same day.
mm,
So the TR1 is not always completed in the way it should be. So this JO form came out for a number of reasons. One, to deal with parties' wishes and get them clearly set out without that panic,
mm,
right? So that in a calm atmosphere, they can, address their decisions, think about it, talk about it, and then complete that form. It's also something, it gets sent to the land registry, so it's very clear, it's clear to the parties. And if it were used more widely, A, it would resolve a lot of this potential litigation that there is,
mm.
and it saves a lot of time. And people understand more in an atmosphere of calmness what it is they're doing and what their choices are as to property ownership. Um, And it's cheaper
Yeah.
than having a fully drafted, all the bells and whistles declaration of trust. If you've got a JO, the bit where you're ticking the right box as you do on a TR1,
Mm-hmm.
it's headed declaration of trust. You wouldn't need to do another. So I don't know whether a lot of conveyancers don't know about it,
Mm-hmm.
or they just can't be bothered, or they think, well, we've got the TR1, why do we need that?
Right.
It's
Yeah.
because they're conveyancers and they don't do this work.
Mm. Well,
But
absolutely, because I know with some of the Talata stuff I've looked at, because of course with Talata, that's what we're doing, aren't we? We're fishing around to get evidence, and I'm thinking to myself, okay, well, look, let's say the old conveyances we still have, the old before the changes to TR1s,
Form
where
19, Form 19.
absolutely, and then you're thinking, okay, say the lady, for example, like the stacking garden scenario, she said, look, for the last 20 years I've been paying twice as much as he has. We've now severed. He's saying, okay, presumption of 50-50, and the onus is on her to suggest otherwise. And I suppose that's where, like you say, if we had something like maybe a JO or some other tangible written evidence, that's going to help massively
Of course it
towards.
is. Of course it is. Because, any sort of document of title that is conclusive as to ownership,
Mm,
that's where it stops.
that's right. This, interestingly, because I know there was that Nielsen case last year, wasn't there? Simberg
Oh,
and
yes,
Nielsen.
Zimberg and Nielsen, Nielsen and Zimberg.
It's the thing about that's it. Now with that one, of course, there were discussions between them, weren't there? There wasn't even
And it
anything
wasn't
written.
reduced to writing.
Absolutely. So it didn't comply with the Law Property Miscellaneous Provisions Act. So that's kind of
Well, the
uh,
Court of Appeal said it did. It was okay.
oh, did they? So
Yeah, I
they
think they
upheld it.
did. I'm going to just check because
Right.
I'm currently proofreading. I'm pretty
Right.
certain they did. I'm just going to check while we're on.
Fantastic. Yeah. So they even thought it complied
Well,
because
the reason I can check this is because I'm currently proofreading the latest edition of the book in which I wrote the chapter.
oh well, there you are. There you are. Fantastic.
Hold on, hold on. Let me, no, it's not in that bit. Hold on. I will find it.
Superb.
We'll get there. Um,
Super,
yeah,
really good.
no,
So
it's
this is so
interesting.
this is where we've literally got it hot off the press for
Ah,
Melissa.
it's,
Yeah.
yeah,
So yeah.
hopefully. Let me just find it. It was written
Yeah.
in case.
Fantastic. And
And
just
one of my friends actually appeared in it.
amazing.
Yeah,
Fantastic.
yeah.
And of course, just whilst you're doing that, for the sake of our viewers, I mean, essentially with that case, it's kind of taking matters even to another level, really, because it's effectively saying that if there's a house, it's bought jointly, and then later, in that case, a husband and wife, they they between themselves informally agree that she can have the house, and he kind of decides to move on.
Sorry, it's not Court of Appeal. It's hang on. It was High Court,
High
but
Court, yeah,
it was an appeal from
was an
D.
appeal.
So
That's
what I say
right.
in the book is it remains to be tested.
Right. Yeah.
But what it says, the question for the appeal court, so the High Court, was whether subsequent agreement means only a subsequent formal agreement complying with section
Mm,
blah de blah, um,
mm,
or whether it's also capable of including a subsequent informal common intention constructive trust.
mm.
And yes, and they allowed
They
the
allowed it, didn't they? Wow. So, so do you think that's right? Do you feel it's going too far? Or I mean, it's good in a way because I suppose it's equity coming in again, isn't it? But
yeah.
then,
So what's I'm just telling you what the judge says. So it was James Pickering QC, um, and he says paragraph 48. An express declaration of trust, whether by way of a TR1 or otherwise, will be conclusive unless amenable to rectification or rescission, which, as we know, is the old Goodman and Gallant, or
mm,
varied by subsequent agreement or affected by proprietary estoppel. It therefore follows that an express declaration of trust is not capable of being overridden by a common intention constructive trust, which arises prior to or at the same time as the express declaration. An express declaration of trust is capable of being overridden by a subsequent agreement. Stack and Dowden says that.
mm,
As to what is meant by subsequent agreement, based on the reasoning and dicta in Clark and Midas and Bahia and Sidhu, While, of course, this can include a formal agreement which complies with the requirements of Law of Property Miscellaneous Provisions Act 18. In my judgment, it is not so limited and may include a common intention constructive trust.
Mm.
To this extent, therefore, I respectfully disagree with the view on this point reached by the judge in Ray Iqbal, where the court did not have the benefit of either Clark or Bahia. So the court, yeah, so that's it. So an informal agreement it's capable of being overridden by a subsequent agreement.
Mm.
I'm a bit of a purist.
Yeah. Mm.
And because I remember having this conversation post Stack and Dowden,
Mm.
where it also appeared that Baroness Hale was saying you could vary a trust, but you didn't necessarily have to comply with the formality.
Yes. Mm.
And I remember one of my slides on my talks for that was someone driving a coach and horses, because,
Yes.
right?
Yes.
And being a purist, I am not happy. I know that's what it does, but I think it's too much of a relaxation.
Mm.
I'd like to see it go to Court of Appeal level.
Yeah. 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 Absolutely. But I say that I was of the same view. I thought
Yeah,
I could see, I can see why, and obviously the cohabitation law for the reasons we said earlier,
yeah,
these very much a lot more restrictive than what the MCA provides for, but it's got to be a limit to it. Otherwise,
yeah.
when we go this far, it's becoming a little too informal.
It's too lax,
It's
I
too
think.
it's too
Too lax.
relaxed, isn't it? That side. Um, and that's where we're going to go into difficulties, aren't we? Because then people are going to say, "Oh, well, we were sitting there outside in the garden, and I remember having a conversation one evening, and he
Well, there's
said,
a whole
you know,
case, I can't remember it, where the agreement is the agreement in the pub car park.
absolutely,
Whole case on that. There's
yeah,
also Hudson and Hathaway.
Hudson Hathaway
The emails.
emails, yeah." Yeah, absolutely, absolutely. That Dobson and Griffey, that's the one. I think was it that one where they drove down to, I think it was Cornwall, if I remember, Devon, and she was saying, "Oh, we were sitting outside the pub and we had a
Yeah, I
conversation
think
that,
yeah,
yeah."
may well have been
I
her.
mean, look at that, look at that. It just gets a bit too relaxed, doesn't it? There,
But the
and
problem with the Talata is when that's all the evidence you ever get,
yeah,
because they never put anything in writing.
mm,
So, so it is the conversation in the pub car park, and
yes,
it depends. If it gets to a final hearing, it's whose evidence is more credible.
yes, yes.
Um, but
That's
I worry about how much we are relaxing things like
mm,
formalities. There is
yes,
a reason that something as important as a trust of land,
mm,
if you want to change that, then you have to have something in writing or
mm,
evidenced in writing. And I
yes.
think that's quite important.
Yes, absolutely. Absolutely. And I agree with you. I agree with you
Yeah.
entirely. So yes, it'd be interesting to see how far that goes, if indeed, it
Yeah, I
does
mean,
go to appeal.
that hasn't gone to, that was an appeal, but hasn't gone as far as the Court of Appeal. But it would be really interesting
Mm, mm.
to have something like that heard at that level.
Yeah, yeah. Fantastic. Really helpful. Thank you. Thank you.
Right, I think it's time for
Um,
one of yours.
yeah, okay. Okay.
Okay. Um, oh, here's a difficult one. Well, I think it's difficult. What is the position with seeking to serve the divorce within any particular time period if electing for solicitor service of the divorce?
Right, okay. This is one of the things, earlier, Elissa, we were saying that, sometimes lawyers are unaware of the expectations placed upon them. This is one of those. When this new act came in, of course, so just over 3 years ago now, there was a change to Part 6 and 7 in terms of the service rules. So you got, for example, Rule 6.6a and so forth, which essentially provides this. If I was going to be taking a responsibility for serving the divorce on the respondent, and I have to do so if, for example, the respondent resides outside England or Wales. So if they live in Scotland, for example, I can't rely on court service. I have to take the responsibility to serve. Doesn't mean me personally, of
So
course,
you'd
but
get an
I've got a
agent, wouldn't you, instead?
agent or post or through lawyers or bailiff service and so forth. But what Rule 6.6a says is there's a time limit. So once the court issued the divorce, I have 28 days within which to effect service. And if I don't effect service within that time, I need to be applying for an extension of time. Ideally before the 28 days is up, but I
Yeah.
can do it afterwards as well, of course. And what's really interesting is this. What if I didn't know this? Or what if I didn't do it? If that divorce goes through, they've now got final order and say, my client goes and remarries, for example, which of course they're entitled to do so. And some lawyer in the future says, hang on a minute, we're going to challenge that divorce. Where does it leave us?
Mm.
And this is where some of you will know there was that tragic case where a lawyer applied for final order, but on the wrong case. And the president said, I'm very sorry, but I'm not going to set aside that final order. Are we going to be in the same situation here? So this is something I would say more and more lawyers they're getting better at, realizing this has to be done. But it's one of those changes that came in,
Mm.
which people don't even realize, is there. And Elissa, you might remember there was years ago, there was this case, Thumb and the Thumb, I think it was years ago. It's the one where the wife lodged the divorce here in England. Hubby lived in Germany.
Yeah.
She lodged the divorce here. She said, look, I couldn't find him. All I knew he lived in Germany somewhere. She served him 4 months later. He said she sat on it. She issued here to have jurisdiction based here, of course, and she sat on it. And he tried to throw out the divorce, but the court of appeal said there's nothing in the rules which says she has to serve you within a particular period of time, unless we're satisfied that it is a strategically lodged divorce. And
Yeah.
here we can't say it was.
Yeah.
But
Yeah,
now there is,
it couldn't be proved that it
yeah,
was.
absolutely. Was now, I suppose, you have got this 28-day period, and it has changed the
That's
goalpost
why they
somewhat.
brought it in.
That was part of the reason, yeah, because it's to stop people from doing this. So, for example, let's say husband, he wants to divorce wife. He doesn't even tell her. He doesn't even tell her. So he issues,
No.
sits on it. Um, and then let's say, because remember, you got to wait 20 weeks. Let's say he serves her week 19, doesn't give her time to go and see lawyers, and then immediately applies for next stage. So it's to stop people from kind of fiddling it that way, I suppose. Um, but you know what clients are like. They'll think of ways, won't they, to try and manipulate,
Yeah.
as long as they don't use us in the process. So there you are. Brilliant. Can I throw another question at you? I think we've got a
Yes,
few more
sure.
minutes, haven't we? Okay.
How are
So
we?
I suppose it kind of ties in again with the with the chattels, the chattels issue, which is good old, prenups, and as you kindly emphasize, the legal effect of those. When a lawyer is drafting a prenup, should they be including pets in a prenup agreement?
Very interesting question, because we know there's been that recent case of Phi and Doe,
Yes.
very aptly named. And interesting because in that case, the judge even comments, I feel like I'm doing a Children Act case, like I'm being
Yes.
asked to deal with residents and contact with in a Children Act case. And it
Yes.
did sound like that. But interestingly, in the wake of that, there is now a lawyers' working group on pets in divorce. And some highly respected people are in it and want their pets. And funnily enough, I did have a case of a young couple who'd split up, former cohabitants, and they literally wanted me to do an agreement about the dog. And
Right.
and I drew something and I had to say, look, I'll do it, but it doesn't, the dog is still a chattel in English law. And therefore, I'm not sure this has a great deal of weight. But as long as you know that, but you want to have something. So I had to draw up something where they agreed, because they'd separated, who was going to have the dog on which days, that they'd communicate if they needed to get the vet or take the dog for any kind of treatment. They'd almost have like a communication book about the dog.
Wow.
Yeah,
Very much like
and
children cases, like you say.
absolutely. It turned into, it
Wow.
was just like a children case. And I had to keep putting all these caveats um, that we don't treat dogs like children. They are chattels.
Mm.
So I don't know how much weight this would have. It is a
Mm,
kind of contractual arrangement between the two of you.
mm,
And then, of course, if you want it to uh, be as to have contractual force, you have to sign it as a deed
yes,
because otherwise, what's the consideration?
that's right.
So,
Wow,
there's
gosh,
all sorts of complications, but currently, a dog is still a chattel.
chattel, right.
It's not, it may not be an inanimate object, and we love our dogs, I know, and our cats and stuff, but where do you draw the line with having pet agreements? Do we have one for the budgie or the hamster or the
Mm,
snake? What do we do it for all pets? Or suddenly, or are some pets more worthy than others?
mm. It's a good
I don't,
question, isn't it?
which,
Yeah.
that's an interesting question, isn't it? So
Mm,
if you're going to have this working party on pets, is it all pets?
mm.
Is it specific categories of pets? What about somebody who keeps butterflies, I
Yeah,
don't, or
exactly.
bees or whatever? Are they pets or is that a different level? Is that a different something?
Mm,
I don't know. Do we then have to amend the Law of Property Act to redefine chattels?
mm. And do
Where
you,
where do
where,
we draw the line?
where you draw the line? And like you say, you've got situations where, lawyer might be doing a prenup, postnup, and then of course,
A pet nup,
petnup, absolutely, petnup. That's a good term, petnup. Do you, I mean, would it make any difference regarding ownership if they were unmarried? So if you're into realms of then, Talata
You're
and
going to start having an argument about the beneficial interest in the dog. And I think in Fido, the judge says, we're not going there.
yeah,
We're not going
yeah,
down there. But
mm,
interestingly, he did look at more economic arguments, like who maintained the dog, with whom did the dog live,
mm,
who took care of it, who fed it, who paid the vet's bills. And what was interesting is the husband in the case was really not interested in the dog as a pet, but interested in the dog as a litter producer and an
right,
income generating
right,
item.
right. So kind of income stream in that way,
So,
yeah,
yeah.
yeah,
So, in a sense, I mean, and you can have anything as an income stream.
mm,
It didn't doesn't have to be a live thing.
mm,
So, although he was after the dog, when you sort of really drilled down into the reasoning,
mm,
for him, it was purely economic. It
mm,
wasn't about the dog. It wasn't about the dog's welfare or well-being.
right. Amazing, isn't it? And this is where just looking at that, it's so much like what we have in children proceedings, don't we? The
Yeah.
welfare of the child, paramount
Yeah. So he
considerations.
was using the
Yeah.
dog as a pawn, right? As some people do with their children,
Mm,
unfortunately.
mm,
And the judge sort of got to the bottom of it and said,
yeah.
actually, the dog's going to stay with the wife because she's been the carer, she's done this, it lives with
Mm.
her. Da, da, da. Yeah.
Really good.
So it
Fantastic.
did.
Yeah.
The outcome was very much like you would expect if it was dealing with a child.
Mm, mm,
But again, much as I know, we are a nation of dog lovers,
mm,
I'm beginning to think we're going a little bit too far.
mm, mm. It's interesting, isn't it? And like
You
you
know,
say, where
a
where do
horse is
you,
a
yeah,
chattel.
exactly.
A
Where
horse
do
is
you,
mentioned in the act.
yeah, and where do you then draw the line? Because
Yeah.
of course, because unless we're careful, if we do then, say, look, it's going to apply to, I don't know, dog, a cat, a rabbit, a
The
budgie,
goldfish.
then of course there's going to be somebody there who's going to say, hang on a minute, and then you've got a equality argument there. Then you're into the human rights arguments, Article 14 discrimination. Where do we stop?
Animals have rights,
Yeah,
even if it's
absolutely,
just their owners. I mean,
absolutely.
are we going to have an Animal Rights Act
Yeah, really
for
interesting.
dealing with I don't know.
Mm,
I worry that we're living in a very strange time
mm, it's
that
interesting.
I was very surprised to see that there is this working party that have already met in Parliament and spoken to MPs and stuff, that there is a working party to deal with pets.
Mm,
And on one level, I think, yes, why not? Because, a dog is one's best friend. And I get that because I have my
mm,
own grand dog
mm,
that in many respects greets me more. emphatically sometimes than the grandchildren do. So,
Mm,
and I really appreciate that. And he's great company and I love him
yeah,
to bits.
yeah.
But he's still a dog.
Mm,
So
amazing.
I don't know. I've probably said something that's horribly unpopular. So I hope,
No, it's good. It's good to, chew it over, isn't it? And think
yeah,
about it, like you say. So no, that's really helpful.
yeah.
Fantastic.
I
I
think we've
wonder
got
if
time for one more from
we got,
you.
okay, yep, that's fine. So, do you want to, let's
So,
go.
since we're now into the area of non-fault divorce, is there ever an opportunity to seek the cost of the divorce from the other party?
Absolutely, absolutely, there is. That's never, that's never gone. And in fact, if we look at, for example, practice direction 7A of the FPR, it still allows for it. It's not going to be as common, of course, because the days of leading adultery, desertion, 2 years are gone. Adultery behavior are gone, of course. But people being people, they're gonna be difficult. They're going to, for example, be elusive. Say I'm for wife. We're desperately trying to serve the husband. He's moving from one address to another. He's not playing ball. I've had to pay money for bailiff service, process service. There's obviously our fees. There's the stress, the grief of it all. Costs money. The divorce fees, as some of you will know, went up just yesterday. It's now
Oh, I
gone
know.
up from, a lot of the fees have gone up. So of course, just the issue fee, is hefty in itself. So in those kind of
What's
situations,
it gone up to?
absolutely.
Is it something like over 700 or something?
It's now, I think it's 632, I think it was, if I remember. It was 593, and
It's a huge chunk for people, isn't it?
massive, absolutely huge. And then, of course, on top of that, you've got obviously the lawyers' fees and, the time and energy involved there. It's costly. So for those kinds of circumstances, absolutely, there will be consideration of costs. And the way it's normally done is, and this is sadly, Elissa, where there's cost in even pursuing costs, in the sense that they have to do a D11 form that
Yeah,
costs
they're going to
money.
make the application. Yeah,
Absolutely. So there's a D11, there's the cost element in that. There's obviously lawyers' fees. You then submit the application. The other side normally has about 14 days to respond. Hopefully the judge will deal with it on paper. If not, they may list it for hearing. Then there's another cost. So all of these things. So it is there, but as you can imagine, people are not pursuing them as often as they used to.
yeah.
Uh, so
What
uh,
do you do in a situation where you've had a separation agreement, you put that into a draft order, you do your Form A for dismissal purposes only, and you do a joint C81 as you think you ought to,
mm,
send it to the other side, you hear absolutely nothing.
mm,
And the other
yes,
side tells your client, I'm not going to cooperate. Why wouldn't you cooperate, for
yeah,
heaven's sake?
yeah, absolutely right, absolutely right.
And what do? Do you then have to do a notice to show cause?
Yes, yeah, I would do a notice
Really?
of show cause, absolutely. And even though it's a
Yeah.
common law, yeah, absolutely. Even though it's a common law principle, it's still there, isn't it? I suppose it's still enshrined within it. I think Mostyn's always been keen on it, hasn't he? Saying, look,
Oh,
use that if,
absolutely.
you know,
Particularly like when in arbitrations, when people want to
yeah,
challenge. Yeah.
absolutely. And I suppose that ties in with this other form that came in last year, the FM5, the family mediation form. And it's good if when it's used well,
Mm.
it's good for the judge to be able to say, look, why don't you want to do NCDR? What is it? What's preventing you from wanting to go
I'm
down
glad
that
you say
route? And
that because I think this hike in court fees is a good
yeah, it's a
reason.
deterrent, isn't it?
Because
Yeah.
if you're issuing for dismissal purposes only, you don't have to pay the whole lot, do you? You don't
Mm.
have to pay a fraction.
Yeah, that's right. It's much more reduced. That's right. Because it's
Yeah,
an application by consent. That's right.
exactly. So,
Yeah.
there's an incentive,
Yeah.
maybe not a huge one, but an incentive nonetheless.
That's right. That's right. And hopefully, there'll be more use. And I know if we did have more time, we would have then gone on and discussed the potential change in the FPR to the mediation element, because of course it's become compulsory in civil. And is it just a question of time before it'll
I
become
think it is. I
mandatory
think
in?
it is, but
Yeah.
there's a whole sort of ethical side to that
Yes.
because it should, if you want people to mediate, the whole point
Mm,
about it is it should be voluntary.
yes.
If you
Yes.
want, arbitration, it has to be by agreement.
That's right.
And then I don't understand why, if you agree to arbitrate, you agree the identity of the arbitrator, you agree to be bound by the decision, and then you don't like it.
That's right. That's right. That's
It's
right.
already sort of baked in, isn't it?
It
That you
is.
not
It's in.
like it, but you're
It's
going to
in.
agree to it.
Well, exactly, because a judge can legitimately say, right, what I'm going to do, I'm going to put this off for 3 months. I'm going to invite the two of you to go and try maybe arbitration or otherwise. And if you don't, I will take that into account when it comes to the issue of costs.
And it should be
So,
taken into
yeah,
account because, everything is so expensive now, and
yes.
litigation particularly. And unfortunately, obviously, none of our audience, and certainly not us, there are lawyers who see a potential client as a kind of cash cow.
Mm,
So,
yeah,
the longer they can keep it going,
yeah,
that's not good for any of us.
not at all. Absolutely.
Yeah.
Absolutely. Fantastic. Brilliant. Well, thank you
Oh
very
my
much
gosh, I think
indeed. Thank you very much indeed. And it's a shame because if we had more time, we'd just keep going, wouldn't we,
oh,
and
you and I
discussing.
could go
So
on all
it's
day.
fantastic. Really, really good. So there we are. So that's all we've got time for today. And of course, thank you to everybody for attending the Law 2025 online Family Law Shape the Debate. And if you would like to submit a question for the next Shape the Debate, don't forget to sign up to receive emails from the solicitors group and be notified of future sessions. So there's still time to book and watch the full pre-recorded content from the law online. It's accessible for 90 days from the day of purchase and allows you a time and place obviously convenient to you. And you can book and find out more about this by going onto the solicitor's website. And finally, of course, don't forget to fill out your feedback forms once you've completed your law online webinars. And by doing that, you'll receive the CPD certificate. So can I thank Elissa? Thank you so much. I think it's been fantastic, us being able to discuss matters today and having the debate. And can I also obviously thank everybody for listening in and wish you the best
And we
for
should
the
all
future.
thank Safda too,
Thank you.
because without him, we wouldn't be having a debate.
Thank you. Fantastic. Super. Well, thanks everybody and enjoy the weather. I think we've got some hot and cold weather coming up, haven't we? So we'll see how we get on. And we'll see you next time. Thank you very much. Bye for now.